Great. Cool. So, is this question paper visible to you guys? Somebody can answer.
Yes.
Okay. Cool. So, after each question, if you guys have a doubt, of course, unmute and ask because I can't see the chat, or I will be able to hear you guys raise your hand, but still unmute at the end of each question. Okay. So, one second, I'll just keep the answer key also ready. So, we are doing set number. This is set B, right? Cool. So, I think we'll keep this like this. Okay. So, set B is open over here. All right. Oh, I can't, unfortunately, can't keep it in separate windows. Okay. So this was the 2023 exam, as in it happened on May 7th. And I wrote this exam only, and this is the exam that I have passed. But unfortunately, I don't remember most of the questions or the answers as well. So I might go wrong. But we are not preparing for my exam, it's your exam. So let's just try and understand each question properly. Cool. So Patent Agent Exam 2023 under Section 126 of the Patents Act. So I already told you guys, right? All the sections in the Patents Act are grouped in batches. So Section 83 to Section 94 are all dealing with compulsory license. So in your mind, already create this image in your head. Like imagine the Patents Act visually, Section 1 to Section 160, and in that 83 to 94, block it as compulsory license. So you don't have to remember it at all. Whenever a question comes in the paper regarding any section number from that, you'll know automatically it's related to compulsory license. Okay. Similarly, Section 120 to like 130 is related to the patent agent exam itself. As in 118 talks about who is eligible to be a patent agent. Like you have to be an Indian citizen, you should have a science degree, should be above 18 years, 21 years of age, stuff like that. So 118 to around 130 is related to the patent agent exam itself. So when you read Patent Agent Examination 2023 under Section 126, what does that tell you? It already gives you a clue, right? That this is going to be part of the regarding the patent agent selection process. So it talks about who all are there in the register, what happens if you don't pay a membership fee, how long do you have time to pay a renewal fee, rubbish like that, and who all, what are the powers of a patent agent, stuff like that. I think it's very simple. There's nothing to explain it. You just can read it once. Okay. So apart from that, it's 10:30 to 12:30. That means it's only a 2 hour exam, and there's no negative marking. So attempt every single answer. Okay. Don't leave anything. So it consists of three parts. Part A is 60 marks, part B is 10 marks, and part C is 30 marks. Let me tell you, this part C is the most important because part A is very easy questions and part C is the most tough questions. Okay. Part B is kind of irrelevant because 10 marks makes no difference. So you'll have to try and max out your 30 marks here because this is more than one correct answer. So it can either be two questions which are right, two answers which are right, three which are right, or all four which are right. So this is where you end up losing most marks, right? So in my first time when I gave it last year, this is where I got screwed. I was able to answer only three out of the 10 questions. So it's 10 into three. Okay, so 10 questions of 3 marks each, and I got screwed in this section only. So you'll have to make sure that you correct get most of the ones correct over here. So this time in this year's exam, I think I got 6 right. So 6 into 3 was 18 marks. So this is where you lose most marks because even if you miss one option out of, even if two that you marked are right, but if you've still missed the third correct answer, you have still lost 3 marks. Okay, and automatically your total comes from 100 to 97, 97 to 94. Yeah, you're pretty screwed. Cool. So part B is just based on true or false. So it'll either be statement one, statement two. You'll just have to pick which is true, statement one or statement two, either one or two, or neither or both. Cool. So all questions are compulsory. Again, don't leave any questions. There is no negative marking. So please attempt everything. And apart from that, Patents Act 1970, Patent Rules 2003. So I'm assuming you guys have not read the rules properly till date, and even I have not done it till date. So the rules are only like the terms and conditions. So whenever you read something in the see something on the TV, they say, right, read offer related documents carefully before investing. So those offer related documents are these patent rules. So every section in the Patents Act has like all those nitty gritties, right? What is the controller's aunt's name? What is his grandfather's profession? All that extra information comes in the patents rules. So there are a few rules which are important, like section rule number 25C, rule number 25AB, but it's not very relevant. So rule number 138 talks about all the extensions that you can seek, stuff like that. But again, like I've shared a Brahmastra document, right? So go through that. It does mention all the important rules that you'll need to know. Cool. So yeah, starting off part A. So here it's very simple, 60 marks, and these are all 30 MCQ questions of 2 marks each. So it's 30 into 2. And let me tell you, these are all easy. Till date, if you've been paying attention to my classes, you can answer most of them. Okay. So I'll be marking all the answers, and if there is needed, any explanation is needed, I'll add a note. Cool. So first question, we'll go slowly. Sagar, who is an applicant of an invention, drafted the specification himself and filed the patent application and asked his advocate, who is not a patent agent, to appear for the hearing. Okay. Is it allowed in accordance with the Patents Act? So, firstly, this falls between section 128, 118 and 130. It talks about the powers of a patent agent. Okay. So basically, any single person, any citizen can file the patent application. Okay. So Sagar, who is an applicant, he is not a patent agent, he is not an advocate. Is he allowed to file an application? Yes. Is he allowed to draft the specification himself? Yes. And a person who is an advocate, who is not a patent agent, can he appear for the hearing? Even this is allowed under section 128 or something like that. Okay. So is it allowed in accordance with the Patents Act? Absolutely yes. So Sagar can draft the specification, but only a patent agent can attend the hearing. No. As Sagar has drafted and filed the application in himself, only he himself can appear for the hearing. Again, no. Sagar can draft the specification and advocate is allowed to attend the hearing. Answer is C. Okay. Only patent agent is allowed to draft. No, even D is wrong. Okay. So is the answer C for B1? Yes. Answer 1 is C. Okay. So I don't want to open the section. I think you guys will be able to find it. But basically, it states that any advocate can appear as before the controller and any person can file an application. So you'll ask me, what is the point of becoming a patent agent? And that's the whole scam. There is no point to becoming a patent agent. It gives you a certain degree of legitimacy. As in, you can go and tell people that, see, I'm government authorized, you'll have a higher chance with me. But apart from that, nobody else, there's no other need for us to be patent agents because we are already from a technical background and we are already lawyers. So literally there's no point to it. But anyway, so the one advantage is like Sagar over here can never appear before the controller. So once the controller raises objections, like the FER is issued and objections to the patent are there, then Sagar cannot appear before the controller. Only a patent agent or an advocate can appear. Okay. And advocate as in anybody. My dad can appear, Saptarishi's dad can appear, any lawyer can appear. Okay. Then so patent agents right now are protesting. So all the patent agents are saying, now that you're doing this, every other Tom, Dick, and Harry advocate is coming. So there's no importance to our profession, right? People are it's diluting our profession. So they are protesting and demanding that the controller make it that only the patent agents can appear before the controller. Okay. Again, I don't know how possible that will be because it will be struck out. It will be against the Advocates Act of India also as restricting trade and profession. Cool. So question number 2. Students of Ishwari Institute of Technology invented a new stabilizer and designed a particular shape to make it attractive. Okay. So this is purely visual. They had given a name for the stabilizer as Passion. Okay. Further, they made an operating manual for the operation of the stabilizer. They need IPR protection for the entire stabilizer. Could you please help them by matching exact legislation? Okay. So firstly, they invented a new stabilizer, right? Whenever you say invention, it's the Patents Act. Then designed a particular shape to make it attractive. So whenever you're talking about the aesthetic features and the word design comes, it's the Designs Act of 2000, right? Then they have given a name for that stabilizer as Passion. So whenever you give a name to a product and let's say it's used to create a brand, I already told you, right? A brand is also an intangible property. So that would come under the Trademarks Act. Then further, they made an operating manual for the operation of the stabilizer. So whatever you have written inside the operating manual will be protected automatically by the Copyright Act. Copyright Act. Okay. So let's see now. So invented stabilizer will go under the Patents Act. So 1 will be C. Shape of the stabilizer will go under the Design Act. So 2 will be D. So 1C, 2D. Passion will go under trademark. So 3B. And then 4 operating manual will be A, copyright. So it will be 1C, 2D, 3B, and then 4A. So 1C, 2D, 3B, 4A. So answer has to be B. Okay, let's just mark it. So what's the answer for 2? The answer is B. Okay, starting off. So any doubts still here? Kaushik, Uttam, anything?
No, Vishnu. Up till now, it's
No.
all clear.
Ah.
Actually, there's one problem I had encountered while solving these and previous year questions.
Mhm.
There was one. If it comes in this 2023, then there is no issue. Otherwise, I'll let you know that specific question.
Cool.
It's regarding the biological invention and micro.
We'll do it. So the one advantage is every year, no, for some reason, the patent agent question papers match, okay, like format wise. So if some question has come in the previous year, for sure a related question will come this year also. So solving the last 2 years paper is like amazing, because the next year's paper will have very similar questions. So probably the biological material question might come here also. Let's see anyway. So third question: Miss Manisha wishes to file a patent application in India, but she came to know that some of the inventions are not patentable in accordance with the Patents Act. So the second you read not patentable, immediately section 3 and section 4 have to come into your mind. 4 is atomic energy, section 3, you know, right? A to P, right? P for parents, for traditional knowledge. So A to P, not patentable. Could you please help her to match list 1 and list 2 and select the correct code? Method of cultivating rose flower. Okay. Second, you talk about flower, it comes under horticulture or agriculture, section 3H. Then, so 3H would be C. Okay, 1C. Then method of treating brain tumor. Okay. So this comes under section 3I for injection. That will be a surgical method. So it will be 2 will be D. Okay. So sometimes you could even this could even come under section 2B. Anything that is prejudicial to human life or goes against public order or morality. But the more correct match would be 3I. Okay, again, these sections are not designed to like restrict you, it's to expand the definition of what is not patentable. Okay, so it doesn't have to be an exact match. Then bucket fitted with torch. So I already told you, right, like you combining two inventions is not going to create anything unless you prove an extraordinary improvement in efficiency, like Bajaj versus LML. So this would be section 3F, 5 printers, right, where you just combine 5 printers and say, oh, I have 5 times the printing power, this is not patentable. So section 3 would be section 3F. So 3 will be B. So 1C, 2D, 3B, and lastly, solution of salt and sugar. I already told you, right? A mere admixture. Me combining katta meeta and Punjabi tadka is not going to give me a new mixture which will cure cancer now, right? So solution of salt and sugar is a mere admixture. Section 3E for eat mixture. So 4 would be 3E. Man, these jugad ways of remembering, I wish I knew them. Shit, easy to remember. Chalo. So it's 1C, 2D, 3B, and then 4A. Okay, so 1C, 2D, 3B, 4A. So the answer for this is also B, right? So 3 would be B. Cool. So we have got three questions, right? So we have got 6 marks already. So we are on track to passing the exam. Cool. So as part of the PCT procedure, Patent Cooperation Treaty, not the Paris Convention. Second, you read PCT immediately in your mind, 30/31 months has to come into play. An Indian applicant can receive an international search report and written opinion from. I already told you, right? When you file the PCT application, you'll have to select your international search authority, right? So he will receive the international search report from. The options are any international searching authority under the PCT, B, any international searching authority declared competent by the Regional Office of India, C, the International Bureau of WIPO, and D, both B and C. See, the problem with these kind of questions is these are little ambiguous. It's not very clear. And let me tell you one question answer which Patent Office in the 2022 exam, which the Patent Office had said this is right. I did the same thing in 2023. I got the wrong answer. Okay. So these are slightly ambiguous. In general, the answer should be A. Okay. Any international searching authority under PCT, you should be allowed to select. But since they're asking both B and C, I'm assuming that it's a trick question and the answer needs to be both B and C, because any international, the IB under WIPO, uh, see, as far as I know, I don't think the IB does the examination or the search report. So the answer should be B or A. Okay, it can be any international searching authority under PCT or any international searching authority declared competent by the Regional Office of India. This, as far as I am aware, I don't think Indian Regional Office, as in the Indian Patent Office, has any legitimacy in deciding which is competent or not. So I don't even think answer should be B. To my knowledge, I think the answer is A, but let's just see what the Patent Office has decided. Okay, so answer for 4 is again B. Okay, so see, these are all ambiguous questions. The Patent Office does what it wishes to do. So you will lose like 2 or 3 marks in these kind of rubbish questions. But to my knowledge, the answer should be A. Okay. Anyway, moving on. Fifth one, Print Inc. is a large corporation having a sizable portfolio of patents for a single product. Okay. That means for the same product, they have around 8 to 9 patents on the iPhone. Then the product is very popular in the Indian market and some of the patents have been licensed to other companies. Cool. Choose the correct option regarding form 27. Okay, so form number 27 is the commercial statement. So every year on April 1st, when the financial year starts, before like when in 2018 2019 you had to file form number 27. Okay. So form number 27 is your commercial statement, as in all the accounts of your patent. How all did you commercially exploit your invention? Where all did you sell? What were your sales? What is your profit? What is your revenue? What is your loss? So the commercial statement of how you exploited your patent is form number 27. Okay. So what does this say? So this has to be compulsorily filed at the start of every financial year. So it has to be filed on April 1st, and you get like around 6 months time or something to file it. So something like around you can file it in October 1st or something like that. But this year, as in like after this year's patent agent exam, the patent officer released new rules, and you don't have to file form number 27 every year. Okay. So you'll have to look into the rules for this because form number 27's rules have changed. But as far as this question is concerned, so Print Inc. has all this. So it has multiple patents. And what is the correct option regarding Form 27? Let's see the options. Form 27 should be filed by Print Inc., but not by the licensees. Firstly, this is correct. Okay. Form Inc. does not need to be filed by the licensees as far as I am aware because the holder of the patent, the applicant only has to file. Next, Print Inc. can file a single Form 27 for multiple patents that are related to the said product. This is also correct. Okay. Third one, the Form 27 should be filed before the expiry of a time period of 3 months, counted from the end of the previous financial year. So if it's March 31st, April, May, June, I guess so July 1st, you'll have to file it, right? So I don't think this is correct because the period is 6 months. It's not 3 months. So this is wrong. Then Print Inc. cannot file a single Form 27 for multiple patents that are related to the said product. This is also wrong. I think answer is A and B are correct, but B is more correct. Okay. So the answer has to be B. So fifth one is P. Chalo, I'm a legitimate parent agent, I guess then. Cool. Okay. So this thing, the rules regarding Form 27 have changed slightly now. So what it says, as far as I've not read it properly, but I think you don't have to file it every year. I think they have given a breathing space of 3 years. You can file it once every 3 years or something like that now. Check it once again. But again, this is still true. Suppose I'm company like Apple, okay, and for my iPhone I have 10 different patents. I have a patent for the camera, I have a patent for the sensor, I have a patent for the touch screen. So in respect of all those patents, I can file a single Form 27 because it's related to the same product. Okay. And I only have to file the Form 27, not my licensees. As in, if I license it to some manufacturer in China or India, they don't have to file it. The applicant of the patent, the holder of the patent, the patentee has to file the Form 27. Cool. Chalo, nice exercise because you learn so much, right? By answering a question because every question is connected to so many different concepts. Cool. Sixth one, your client being an MNC filed a patent application and paid all the fees applicable. Your client later on becomes uninterested in the patent application and wishes to seek refund. Okay. So for refund immediately, your mind should go to form number 29. So whenever you withdraw an application, a refund of the fees comes under form 29. Okay. So please select the options available to your client. Cool. Your client being an MNC filed a patent application, client becomes uninterested. Cool. So when do you get the refund? So, okay. So your client can assign the application to a natural person and claim refund of the difference in the scale of fees between the fees charged from your client and the fees chargeable from the natural person with regard to all the fees paid previously. So the first thing you need to know is there are different fees chargeable for different kinds of people. Okay, I'll just show it to you so that you guys understand it better. Uh, yeah, I think this has it also. Just a second. Cool, I'll show it to you in the Patents Act only. Wait. Uh, so schedule number 1 or 2 has to have the fee, right? So just a second. Array, this doesn't have the schedule. Wait. Cool. So we have the fees here. So what I want you guys to see here is, so the fee is not the same for every category. Whenever you file an application, whenever you fill any of the forms, there are 30 forms, form 1 to form 30. Okay. So you'll have to fill some form. Whenever you have to communicate with the patent office, some form has to be filled. Okay. So in every patent application, there is a different fee bracket. Of course, I can't pay the same fee which Ambani is paying, and Ambani can't pay the same fee which Jeff Bezos is paying, right? So there are three categories. Any natural person or a small startup or any small entity or an educational institution. So they pay the smallest amount of fee. See, all 160 rupees, 1600 rupees is the least amount of fee. Then any natural person, others alone or with natural. So all this is the same thing. Okay. Then the second one is here. Where is it? 1 second. Educational. Okay. So this is a different category. So this is for e-filing and for physical filing. So whenever you physically submit documents, you'll have to pay a slightly higher fee. Whenever you do the e-filing, online filing, you get a 10% discount. So 1,750, you end up getting a small discount, and then it becomes 1,600 online. Wait, I'll take a question. But in general, there is a different fee that you pay for a natural person, as in a single person filing a patent, an educational institution, and lastly, when a large company, a multinational company, files a patent. Can you mute yourself, please? Somebody has to mute themselves. Yeah. So there's a different fee bracket for different people. Okay. So for a single person filing an application, I'll pay lesser fee than a small entity filing an application than a multinational corporation filing. So what they're saying is, when the patent application filed by an MNC is going to be withdrawn, is it possible for me? So now that I paid a high fee for the MNC, I've paid like 8,000 rupees to file the application. Let's say now I'm transferring the rights. I'm assigning this patent application to a small person. I'm assigning it to Kaushik now. Okay. So now it is a single person, right? It's just a natural person. So now should the patent office refund the fee now? Because now for Kaushik, it would have been only like 2,000 rupees. So should the patent office give him back 6,000? So because don't you think companies will misuse this now? Like let's say a big company like Honda or Hero or TVS, they will keep doing this, right? Once they file the patent application, they will transfer it to some inventor in their own company and they'll get a refund. So the patent office will not allow this. Okay. So that's the question. Let's read, we'll solve it, and then I'll take the doubt. So your client, being an MNC, filed a patent application and paid all the fees applicable. Your client later on becomes uninterested in the patent application and wishes to seek refund. Okay. So please select the options available to your client. So the first option is basically you can refund. You can file for a refund. You can get it back, get your fee back. Okay. Your client can assign the application to a natural person and claim refund of the difference in the scale of fees between the fees charged from your client and the fees chargeable from the natural person with regard to all the previous fees paid previously. I don't think this is possible because this will be used to cheat the patent office. Every company will transfer it to a natural person and claim the refund now. Okay. Then your client can assign the application to a natural person and claim refund of the difference in the scale of fees between the fees charged from your client and the fees chargeable from the natural person with regard to only the fees paid for the request for examination. Again, this is a little complex. Cool. Moving on. Your client can make a request for withdrawal of the patent application. This is what I told you, the easiest option, before the issuance of the first statement of objection, and claim a refund of 90% of fee paid for the request of examination. I think this is the correct answer. And lastly, your client can make a request for withdrawal of patent application before the issuance of the first statement and claim a refund of 50%. Okay. To my understanding, I think C has to be right. But my intuition, because of how much of fuckery the patent office does, I think the answer has to be either A or B. Okay. So let's just read it clearly because they've given both similar options, right? So B says client can assign the patent application. So what is the difference between 1 and 2? Okay, this is respect to for examination. Okay. So by all sense of common sense and logic, the answer has to be C, where you'll get a 90% refund. But trusting in the patent office's power, it might be B as well. Okay. It can be B or C. Let's see the answer. Sixth one is C. Okay. So we were right. We were on the right track. So you can get a refund of up to 90%. Where is it? Sixth one is C, right? Yeah, cool. So what was your question? Yeah, somebody had asked. Go on. Somebody had unmuted themselves, right? Somebody had a doubt. Chalo, let's move on. Cool. Huh.
Actually, Vishnu, it was actually not a doubt. I just wanted to remind that the question I was harping on was question number 13 in the same question paper.
Cool. Great. We'll get to it then. Cool. Seventh one, an inventor living in Shimla, Himachal Pradesh wants to file his patent application along with a demand draft for the amount of fee payable. Okay, so he wants to file the application and he's going to pay a DD now. Please select the correct options available to the inventor. The inventor may send his application by a courier company. The inventor may send his application by speed post. Look at what kind of rubbish questions these are. Both A and B, only A. The answer has to be C. Both A and B. So answer for 7 would again be C. Oh, 7 is B. Okay, so see, these kind of places, everyone is going to go wrong. So for some reason, you can't send it by courier. You can only send it by speed post. Chalo. So no comments on that. So eighth one, your client, a startup which is facing existential challenges. Okay, filed a patent application 6 months ago, which has not yet been published. So the immediate thing that needs to come to your mind is, once you file a patent application, if you have filed the complete specifications within 12 months, it will be published automatically within 18 months. Okay, so 6 months ago it has been filed, but has not yet been published. Your client recently came to know that a competitor has started selling a product which is based on the invention disclosed in its patent application. Okay, so for you to stop the infringement, you cannot file a suit till the grant, but from the date of publication, you have all the rights of a patentee. I think section number 6 talks about all your rights are from the date of publication. Okay, as if you have received the patent itself, but you can't go to court till the grant. Okay, so you'll have to get it published very fast. Okay, so you recently came to know that a competitor has started selling a product which is based on the invention disclosed in the patent application. Cool. The startup seeks your advice on the way forward that ought to be adopted. Please select the most prudent option. So prudent means the most legally careful option. Cool. So first, your client should file a request for expedited examination along with a request for early publication at the earliest. Expedited examination is form number 18A, and then early publication would be form number 9. Okay, so you'll have to learn all this. Form 9 is publication, form 18 is examination, form 18A is expedited examination. Cool. So yeah, this is the first thing that you have to do. Option A is already correct. Next, your client should send a legal notice to the competitor that he will have to pay the damages calculated from the date of filing of patent application. This is wrong. You can calculate damages only from the date of publication, because all the rights of the patentee start from the date of publication. Because if the opposite party doesn't even know your patent exists, how can you charge him for it, right? There is no absolute liability in this case. He will have to know it. Okay, so only from the date of publication. Your client should send a legal notice to the competitor, and he will have to pay the damages calculated from the date of grant of patent. Even this is incorrect. It's from the date of publication. Your client should file a request for expedited examination, a request for early publication, and a request to the controller of patents to stop the competitor from infringing his rights. See, the controller of patents can't do anything. So for you to stop the other guy, you'll have to send a notice to him only. There is no request to the controller of patent. There is no form for this. Okay. So the answer is A. 8 should be A. Are we right? So eighth one is A. Cool. So we have got 2 wrong answers now. So we'll keep track of that also. Then ninth one. A patent was granted within 1 year from the date of filing the patent application. Cool. So it was like super fast. Like the publication has happened, the examination happened, FER has been responded to, everything has happened within 1 year. The patentee will have to pay the renewal fee without taking any extension before the expiration of the second year from the date of the patent in respect of the third year. Option 1 is already correct. Okay, so you'll have to, the patent is valid for 20 years, correct? So for the first 2 years you don't pay any renewal fee. All that renewal fee you've automatically paid by virtue of you filing the application, because when you file the application you have to pay fee, right? 1,600 plus additional for your claims and all that, and 8,000 if you're an MNC and all that. Cool. So you've already paid for 2 years. That means you have to pay from the third year onwards, correct? So from what date will you file the renewal fee? So what is, one second. So before the expiration of the second year, from the date of the patent in respect of the third year. This is correct. Only from the third year you'll have to start paying, and you can't pay it in the fourth year. You'll have, for the third year you'll have to pay it beforehand. Okay, otherwise your patent will be lapsed, and you'll have again another 18 months or something to restore it or something like that. You'll have to go through the relevant section. Cool. Before the expiration of the first year from the date of the patent application in respect of the second year. This is wrong, because for the first 2 years it's already paid. Then before the expiration of the third year from the date of the patent in respect of the third year. This is also wrong. I can't pay it on 31st of December for this year. Okay, I'll have to pay it on the first, before the 1st of Jan itself. And D is also not true. Answer has to be A. Okay, so are we correct? 9 is again A. Cool. So coming back, 10th one, Marco files a patent application in Colombia on 9/1/2021. Okay, remember the dates now. 9th Jan 2021, and thereafter claiming priority from said application, he files a PCT international application. I already told you, right? They file a national application, then you file the PCT application and claim the same older priority date. So he has filed, he files a PCT international application on again 9/1/2022. Okay, so 1 year after this, and he's claiming the older priority. Is it allowed? Okay, Marco is interested to file a national phase patent application in India. The deadline to file in India would be, so see, again, there is a problem with this question, because if you file on 9/1/2021, within 12 months, you'll have to file the PCT application. Okay, so technically he has filed it within 12 months. But if it's 9/1/2021, will you take the risk of filing it on 9/1/2022, or will you do it one day before? It has to be 8/1/2022. Okay, 8th of Jan. Cool. Let's assume that it's a valid PCT application. In which case, the priority date is 9/1/2021 only, because he's taking the old priority. So now he has 30/31 months to file the national phase application in India, right? So India gives 31 months. So what is 31 months from 9/1/2021? Okay, so 31 months would be 2 months, 2 years and 7 months. So 2 years would be 9/1/2023, and then 7 months would be 9 July, right? Now July or August. So it'll be 9/8/2023. So the answer would be 9/8/2023. Cool. So that would be 31 months. So is the answer right? 10th one is A. Cool. So we are right. Is it clear? I think if this you guys have understood, you guys have understood PCT. Any doubts here? 10th is A. Cool. Very nice. So where is the highlight? Yeah. So he gets 30/31 months from this date. Okay. So Nilesh filed a patent application on 24th March 2019. Cool. Upon which the patent was granted. Perfect. Go on. Okay, cool.
I Vishnu had one doubt.
Go on.
So, from filing a national application within 12 months, we have to file the international application, but within 30 months, we can file other national applications.
So you have not filed your PCT yet, correct?
Yeah.
You have only filed the national application in Colombia. So for as of now, the PCT treaty is not active. Okay, so you cannot claim 30/31 months till you file the PCT application. Okay, so as of now, when he filed the 9/1/2021, only the Paris Convention is valid. Okay, so according to the Paris Convention, he can file in other convention countries within 12 months. Correct? No, this is clear. So he has 12 months to file in other countries and also to file a PCT application under the Paris Convention. So once he files the PCT application within 12 months, the PCT kicks in. Paris Convention is kept aside. PCT has power now. So automatically, now that he's claimed this priority date 2021, and now PCT is also in force, now he gets 30/31 months from this date. So it's very interesting. First, he uses Paris Convention, and then he utilizes Paris Convention to claim PCT. Okay, it's very interesting, the concept. Is it clear?
Okay. Just one thing. So the PCT application need to file within 12 months, right?
Yeah, for sure.
Okay.
Or he can directly file the PCT application, but in a country like India under Section 39 requires that you file the national application first. Okay, so even in India, he'll have to file this first, and then he'll have to file the PCT, or you'll have to get the foreign filing license under Form 25. It's very complicated. Don't go for it. Okay. So
actually, Vishnu, could you just revisit this? Actually, I could not get it where you used Paris and PCT
cool.
along.
So forget Colombia. Okay, let's say India only. So India requires what? Either you need a foreign filing license, or you'll have to file the Indian application and wait for 6 weeks. That's very simple. Everyone does that only. Okay, so assume it's India only. So he files the national application on 9th January 2021. Okay, so in Jan 2021, you filed your national application. So now the patent office doesn't know what your plan is. Are you filing a PCT later on? Are you going to apply in other Pakistan and USA? They don't know. They don't care. So with respect to them, with respect to the patent office, you have just filed a normal application. Okay, so by default, by virtue of India being a member of the Paris Convention is in force, which means now that you filed the national application on 9th Jan, you have 12 months time to file in any member country. You can file it in US, in Japan, in China. You have a 12-month breathing space. Okay, why don't you have 30/31 months? Because you have not filed a PCT application. The Patent Cooperation Treaty, PCT treaty, will kick in only when you file the PCT application. But till now, you have not filed the PCT, right? So only the Paris Convention powers you have now. You have 12 months of time now. Cool. So till you file the PCT treaty does not kick in. Okay, let's forget 9/1/2022. Let's say in April of 2021, you file the PCT application. Now the patent office knows that you filed a PCT. You're trying to claim all the powers of the PCT treaty, and now the world is aware, right, that you filed a PCT. Now that you claim the older priority, the Patent Cooperation Treaty kicks in now. Okay, so the Paris Convention is set aside, and now that you have claimed the older priority date, now the PCT's benefits, as in 30/31 months from this date, kick in now. So now you have 31 months from this date, which becomes 9th August 2023 now. Okay, so what I meant was, in a country like India and in most applications, you'll always file a national application like this first. So initially you use the Paris Convention, and using the Paris Convention, you invoke the PCT treaty. Is that clear? That's what I said. Any questions, Uttam?
No, I think it's clear now.
Spot on. Cool. So this is the advantage of solving the question paper. All these concepts become very clear because when you think of it in such a practical manner, right? It becomes very clear. Cool. So Nilesh filed a patent application on 24th March 2019. I'll give you guys a break at question number 15. So just a little bit of focus. 24th March 2019, upon which a patent was granted. Cool. So patent has been granted and all that. So the who asked the previous doubt before Uttam? I just want to recognize the voice. Who asked the previous doubt?
Am I
Saptarishi.
Oh, cool. Okay. So 24 March 2019, the patent is filing date and the patent has been granted. Cool. So the priority date is again 2019 only. The fact of grant of patent was published in the official journal on 3rd Jan 2022. Cool. So even after grant, it will have to be published. So this date is irrelevant. So the grant has been published. That is not really relevant. The power of the patent starts from 2019. So it's valid till 24th March 2039. Okay. Nilesh develops a further improvement. Second, I say improvement, section 54 patent of addition has to come to your mind. Okay. Of the said invention. Upon conducting a patent and non-patent literature search. So he does a small search. Nilesh finds out that the improvement is novel as compared to his own patent. However, the improvement was disclosed in someone else's patent application, which was published on 23rd Jan 2022. Okay. So much after this date. Forget this date. This date is just there to confuse you. So after 2019, in 2022, somebody else has written some research paper. Dekisuke has written has filed another application which discloses the improvement. So Nilesh is in a position to file the application for patent of addition on 4th Jan 2023. What should Nilesh do? So the first requirement of patent of addition is it has to be after the filing date of the original patent, of the main patent. So that is valid. Secondly, I've already told you guys that the improvement does not have to have an inventive step. Okay, it can just be a small improvement. The test of inventive step is not that strict for a patent of addition. Cool. So what should Nilesh do? Nilesh should file an application for a patent of addition as the improvement is novel vis-a-vis his own patent. So they're saying even if the novelty fails with respect to another application, it's still novel with respect to his own invention. So he should still file for it. Second one, Nilesh should not file an application for patent of addition as his patent application would be devoid of novelty. Okay, so they are saying since there's no novelty because of another application, he can't file it. Third one, Nilesh should not file an application for patent of addition as the same cannot be filed beyond the expiry of 1 year from the date of publication. Complete rubbish, it's wrong. And then D is none of the above. It's very rarely option D, okay? Very rarely none of the above is correct. So always eliminate D by default. C is out. So the answer has to be A or B, okay? To my understanding, the answer has to be A because with respect to his own invention, I already told you, right? A patent of invention addition can be filed only by the same applicant. Okay. So if this other application has been filed, let's say there is another application filed by Dekisugi and that has already incorporated this feature, he will never get the patent on that. Because why? Because there will be no inventive step with respect to my own invention. Okay. Because since my invention already has an inventive step and this improvement is not so big, then even if some other patent application is claiming it, he will not get a patent or a patent on addition because the applicant is not the same. Only I have the right to get the patent of addition. Okay. So since there is an improvement vis-a-vis his own vis-a-vis his own patent, he should file a application for patent of addition. So to my understanding, A has to be right. Let's see 11A. What is 11? 11 is B. Okay. So chalo, I was wrong. So the answer is Nilesh should not file a patent of addition as his application would be devoid of novelty. Okay. So again, these are all places where the patent office itself is little ambiguous on. It's not very clear. Okay. So it's always case to case basis. But again, remember this. Okay. So in general, they're saying if there is no novelty, you cannot file a patent of addition. Cool. Question 12. A post-grant opposition is filed against the patent owned by the company Shelf Life Private Limited. Second, you say post-grant opposition, section 25, clause A, I think, right? Section 25B. 25B is post-grant opposition. That means after the grant of the patent is filed against the patent owned by the company Shelf Life Private Limited. The patentee does not desire to contest opposition or leave his reply and evidence within the prescribed time limit. The patent shall be. So what happens if you don't respond to the opposition? Okay, if you don't contest it or if you don't give a reply, what happens? Ex parte decree, first of all, and second of all, it will be deemed your patent will be revoked, right? So will it be deemed to have been abandoned? No, because abandonment will happen only to an application, Post grant means your patent has been granted, so it can't be abandoned now. Only an application can be abandoned. Will it be deemed to be withdrawn? No. Only a patent application can be withdrawn, not a grant, not a granted patent. Will it deemed to have been terminated? No. Termination means the expiry of the patent has happened, 20 years have passed. Okay. So only the option left is revoked. That means the patent which has been given will be taken back. Okay. So the answer has to be B. 12th one is B. So this is again grammar. There's no logic to this question. 12th one is B. Cool. Then we come to question number 13. Your client, Pat Bio, wishes to file a patent application in the Indian Patent Office for an invention which uses a biological material from India. Cool. Arrange the steps for protection of said invention in the most likely chronological order. I can tell you beforehand I'm screwed in this answer. Cool. So again, there is a lot of ambiguity to this. There is no clear-cut answer regarding this because who's filing it with biological material? Like not many people, right?
Actually, Vishnu, in the same question, even with the answer given by the authorities, I could not gather the logical chronological order because it wasn't making any sense.
See, the
I think
problem
you
is
need
who's
to-
setting these papers? People who become patent agents like us, right? So nobody is clear about the law, right? So let's get
Okay.
on with it. Let's see. Let's try and go logically. I don't remember what I did for this question, but let's see. So first option is filing of the patent application. You guys already know beforehand that the deposit has to happen on with the application's filing or before it. Okay. So this is not the first option. At least one is not first. So you can already eliminate option A. Okay. Option A is gone. Next, 2. Deposition of the biological material in the recognized depository. Cool. This deposit has to happen, correct? But before that, under the National Biodiversity Act of India, under the Biodiversity Act of India, you'll have to take permission. Okay. Let's say that it's some kind of protected plant life or some kind of protected animal's skin or something like that, some kind of fur which is protected. You'll need to have permission, right? Because if the police catch you with it, it's illegal material, you'll be arrested now. Okay. So always you need to have permission before you can submit something, right? So see, before you deposit it, you'll need to have permission to deposit it. So submitting permission from the National Biodiversity Authority, to my understanding, this has to be the first option. Okay. But seeing the option here,
Exactly my point.
but seeing the
Yes.
options here, 3 is not the first option here at all. Okay. So forget that now. But taking this permission has to be one of the first 2 steps. So I am already assuming section C or D is the correct answer. Okay. But forget that for now. Publication of the patent application happens very late. Grant of the patent happens even after the patent has been published. Okay. So 1, 4, 5 are the ending. Okay. You can already be very clear that 1, 4, 5 are already at the later stage. Okay. So 4 and 5 are the last 2 options. You can be clear on that. So option B is eliminated because 4 and 5 are not the last options. And option A is also eliminated because of the fact that this thing, filing is not the first step. Okay. So the answer has to be C or D. Both are ending with 4 or 5. So let's try and decide now. So the first option over here, since submitting permission is not the first thing, deposition has to be the first one. So 2 has to be the first option. Okay. Followed by submitting the permission, followed by filing, followed by publication, followed by grant. So the answer has to be C. But let's see what the patent office has done. I don't know why weirdly my memory is telling me that I put B, but I think the option is C only. So what is 13? Is B. Okay, see, my memory was right.
That
Okay.
that is what I am telling you. It's just
Oh.
it doesn't make sense
Hmm.
even by the logical flow.
Cool. But anyway, let's respect the patent office at least here. So let's see what the patent office is saying is the correct answer. So firstly, they're saying deposit your material, then you file the application, then you submit the permission from the biodiversity authority, then then you do the publication of the patent, then you submit the permission from the authority, and then you get the grant of the patent. Very
And even I
problematic.
looked
Hmm.
up in the Patents Act. I found some bits and pieces of the answers, but not the exact logical flow. Because
Cool.
in section, I think section 8 or something, there it is given how you have to go for the biological materials. But
Huh.
yes, in section 10,
Hmm.
you come to the clause 4.
Hmm.
Therein there are provisions that
Hmm.
provide the answer, but I think
Even
there
that
is
regarding
nothing.
permission, there is no permission option. Hmm.
They have not given that, so
Cool.
I was confused in
But
this.
as of now, since you guys, this is what the patent office believes is correct. Wait, 13 is B only, right? Let's just check it off. 13 is B for set number B. Cool. So let's just be clear on the procedure. First, deposit your material, Next, file your application. Next, get your application published. Then, for some reason, submit the permission from the NBA. And lastly, get the grant of the patent. Cool. Then 14th one, we'll take a break on page number 15, on question number 15. Two very small questions. Parent application filed by Rajesh is refused by the controller, and said decision is communicated on 2nd May 2023. So May of 2023. Rajesh can file an application for the review of controller's decision by, guys, this is a purely timeline based question. I don't know the answer to this, but to my understanding, review of a controller's decision always has to be within 1 month. Okay. So it has to be within June. So it has to be.
Section 77, clause 1 G and F, I think, sub clause
So
1.
what is the answer then?
Let me just.
So 14 is B. Okay. So the answer is again 1 month only. So it's again. So always, whenever a decision is made by the parent office of the controller, you get 1 month's time. Okay. In general. So something has 2 months. Okay. One thing has 2 months. Everything else it's 1 month. So if it's 2nd May, you get time till 2nd June, which means one day earlier. So 1st June. Okay. Then number of members in the opposition board. So I've already told you opposition board has to have 3 people, right? But again, I'm not fully clear on this now. So 3, including chairman, has to be the answer. Let's see, the answer 15 has to be B. 15 is B. Okay. So cool. So all this you just have to mug up. There's no logic to all this. So 3, including the chairman. But as far as I'm aware, if you go by the current rules, I don't think the chairman is also a part of this. Oh no, chairman. Correct. The controller is not a part of this. Cool. So the controller makes a group of 3, and he constitutes this as the opposition board, and he appoints a chairman in this. So it's 3, including the chairman, but it does not include the controller. Cool. So this is the correct answer. Cool. So take a break and let's meet again at 11:05. Okay. I won't start before 11:05. So take a break, go to the washroom, chill, and come back.
Vishnu,
Go on.
is this a two? This will be a 2-hour class, or is it
Uh,
more than?
Whenever we finish this thing, right? So how many more questions we have? We have till question 50. So we have another 25 questions.
I think wouldn't it be more wise to go up till 20 question and then go through section B and section C, part B
Section
and
B
part
and
C,
C. That's what we're
part
doing.
B and part C,
Ah,
because I
that's
think we are getting a fair idea about how the questions are in the part 1,
Let's see
part
how
A.
energetic everyone is. Let's finish 25 and then decide. Cool.
Okay,
So
sure.
yeah. Take a break, guys, and be back. Right, I'm back. Is everyone back? Subramaniam, are you there? I'll ask you questions now.
Yes, I.
So tell me what is form number 25 then?
Found out 25. Just I just open Google and keep on the side.
And you should remember, because I've mentioned form 25 in every 20 minutes. I've mentioned it. It's foreign filing license.
Or in fact, yeah. Wait, most important forms are 20, 1, 25, 27, 29, and wait.
Wait, I'll give you guys a way to remember the forms. Cool. At the end of this meet, I'll give you guys a way to remember. See, the thing is, I have not read the form names since the last year parent agent exam. Okay, I studied it for May last year. But when you learn it in a clear manner, you'll never forget it. You'll remember it forever. Okay, so come back now. Where are we? Question number 16, right? So I'll be starting. Everyone mute your mics. Is everyone back? Kaushik is back. Saptarshi is back. Uttam is back. Yep, cool. We'll be starting then. Cool. James, a citizen of Norway. You need to immediately remember that. Other country citizens, we don't care. Only if they reside in India, we care about it. Somebody has to mute themselves. I think Subramaniam. Yeah. So
Yeah.
James, a citizen of Norway, can file a parent application directly in India. Can file a parent application in India only after filing the same in Norway. Can file a parent application in India only through the PCT route. Can file an application only in Norway, not in India. This is garbage. Eliminate D automatically. Next, can file a parent application in India only through PCT route. This is also not true. He can come through Paris as well. Next, can file a parent application in India only after filing the same in Norway. Very sketchy. I don't think this is also true. And then lastly, can file a parent application directly in India. To my understanding, this has to be the right way. Let's see if the gods of Indian Parent Office agree with me. 16 has to be A. Chalo, thank God. Then coming back. Cool. Where are we? Okay. So then, George Sebastian is a US citizen residing at Bangalore. So this question comes every year in the paper. Last year it was some female name. She was working at NASA and then she was residing in Bangalore. And some reason Bangalore always comes. So learn this question properly. George Sebastian is a US citizen residing at Bangalore and working at an MNC having offices throughout the world. So the second the residing comes into play, you are an Indian resident, Patents Act applies. As part of the research team, George invented a mosquito repellent. However, as per the company policy, the application for patent should be first filed at US Patent Office. Okay, so his company policy tells that he has to file the first patent in the US Patent Office. But does Indian Patent Office care about his company policy? Of course not. Okay, in which case, if he has to file it first in US, what should he do? He has to fill form number 25. Subramaniam won't know which form it is, and his client is screwed. So George approached you for getting advice as to whether he has to do any formalities with the Indian Patent Office. Cool. So what are the options? As George is a US citizen and company is a MNC, there is no requirement from the Indian Patent Office. Scratch this option out automatically. Next, it doesn't matter if you're a citizen of another country, you're still residing in India. As George is residing at Bangalore, he has to obtain permission from Indian Patent Office to file first application in US. Option B is already correct. Form number 25, foreign filing license. As George is residing at Bangalore, he has to obtain permission from US Embassy in India to file first application in the US. What the fuck is all this, man? No, he doesn't need all this. You don't need US Embassy's permission and all to file application. As George is a US citizen, he has to obtain permission from Indian Embassy in the USA for filing first application in the US. Okay. So firstly, regarding this permission from the embassy, this question came in the 2022 paper. And even I'm not fully clear what embassy permission you need. But as far as this question is concerned, he needs this permission. Okay. Option B has to be right. Let's see if section 17, question 17, the answer is B. 17 is B. Okay. But regarding embassy, there is a question. So if we have time or if you guys are free next week, we can solve the question to 2022 paper as well. And there is an embassy question. Like all four options are, you have to get permission from US embassy, you have to get permission from Indian embassy, you don't need permission from some embassy, and are both true or not. Okay. So there is some embassy requirement as well. Cool. But moving on, option question 18.
Vishnu,
Huh.
just to stop you here. Actually, the form 25 specifically mentions now this form is for permission for making patent application outside India.
Huh.
Therein it says the explicit permission from the controller. I think that patent officer.
Patent
So how does-
officer. Here they're talking
Patent
about
office. No,
the,
no.
uh-huh.
As the answer is given, na, to obtain
Mhm.
permission from Indian Patent Office.
Uh-huh.
So that Form 25, therein the Section 39 in Rule 71, they explicitly mentions Indian Patent Office
Okay.
as the sole bearer of granting permission.
Hmm.
So how come the embassy role is there
See,
with regards to
to my
permission?
understanding at least, the embassy will supersede over every patent office because your embassy is pretty much your country's constitution operating abroad. Okay, so the embassy will always stand supreme to the patent office. But again, we'll visit that question, but that was a little more complicated. It was not about the filing, it was something else, like where they're trying to file something and something related to atomic energy. Do you need the embassy permission? And the answer was yes, you needed the embassy's permission. I'll try and find the question.
No,
I'll share it on the group.
if the sector is something related to national security, I think
Hmm.
then maybe the thing is different.
Let's see. Let's have a look at it later. Cool. So question number 18. Uh, see, definitely they have not given these two options without reason. That means the embassy provisions do exist. There is some permission that you seek from the embassy. Let's see it later. Question 18. Three applicants applied for a patent and patent was granted to them. Is it possible for three people to apply for a patent? Answer is yes. And there is another fact that you guys can remember. You can have up to like 8 inventors or 8 applicants. Okay, we just check that once. You can have up to 8 inventors for every invention. So which of the following is true? Cool. There is no specific contract between them. Okay. All are having equal undivided share in the patent. Already option A is correct. First name holder in the patent application will get majority share. This is not correct. Sharing will be based on the alphabetical order. Again, rubbish. Sharing will be based on the date of birth. Again, this is wrong. Okay. So in general, all have the same undivided share in the patent unless they have a specific contract between them. But in this case, there is no specific contract. Let's say we all have a specific contract. All 5, 6 of us in this meet apply for a patent and we have a specific contract. I tell that Saptarshi will get 10%, Uttam will get 15%, Kaushik will get 18%, and I personally will get 85, whatever is the remaining percent. But if there is no specific contract, it's an equal undivided share. Okay, an equal undivided share means this is something very important for you guys to understand. If your patent application has 10 claims, okay, and 4 of us are there as the applicants, it doesn't mean that the first 2 claims belong to me, next 2 claims belong to Kaushik, next 2 belong to Saptarshi. No. All of us have control over all the claims of the patent, okay? But all of us have an undivided share. You cannot divide it, you cannot partition it, but all of us have, in general, an undivided share over the entire property. Let's say there's an apartment, okay? An apartment with 100 houses built on a small piece of land. 100 floors are there, okay? Let's say the apartment is demolished after 50 years. Now, all the owners of the apartments have an undivided share in the land. It doesn't mean that you're going to divide that land into 100 check boxes and each person gets one checker box. No. All of you collectively have an undivided share over the site property. That's what it means in property law. Okay, so that's what I mean when I say equal undivided share in the patent. So moving on, 19. Mr. Suresh has 2 inventions related to a
One
table.
note from previous question.
Go on. Huh.
That is, say, patent. See, the patent will change depending upon the number of claims.
Mhm.
So how can you still give an undivided? I mean, an equal share actually.
No. A patent will have multiple claims. Okay. So let's say I have a laptop. First claim is for my laptop camera. Second claim is for the keyboard. Third is for the mouse. Fourth is for the mouse, the touchpad. Okay. So each claim will be placed separately as a separate claim. So the patent office might strike out claim number 4, might strike out claim number 5, but I already told you the claims will independently exist. That means even if 4 and 5 are struck out, 1 and 2 will still exist. What I mean is, let's say you're licensing some invention to a third party. I can license only 2 of the claims. I can license only claim 3 and claim 4. Okay. I can say that you have the license only for my touchpad sensor and my camera, not for the whole laptop, not for my mouse, not for my keyboard. Okay. So it's possible for me to isolate and license it like this. What I mean is, let's say 4 of us are the applicants in this laptop. It doesn't mean that you own claim number 1 and 2, claim number 3 and 4 is with him. So when we license out only this touchpad sensor to the other licensee, it doesn't mean that only you will get royalty because claim number 3 is yours. Okay. All of us own all the claims collectively, and all of us will get royalty in respect of that claim being licensed out. I'm just saying you can't make hard divisions in the patent. It's an undivided share. That's it. Moving on. Question number 19. Mr. Suresh has 2 inventions related to a tabletop grinder. Cool. He filed patents for both inventions in the Indian Patent Office. So both are related to a tabletop grinder. I'm assuming slight improvements are there. One maybe has some kind of improvement and the other is the same thing. For both inventions in the Indian Patent Office. Patent was granted for one of the inventions and the other was pending. Mr. Suresh assigned all rights in both the cases to MS Birdfly Industries. Now, which forms are required to update the same in the patent office records. Okay, so here I became a little over smart based on the 2022 answer. Again, I told you, right, patent office did some fuckery in 2022. Based on that answer, I changed my answer over here and I got it wrong in 2023. Okay, so to my understanding, the correct answer has to be so form number 16 is registration of title and interest. Wait, form number 16, form 13 would be amendment. Yeah, form 13 would be amendment of the patent, and form number 16 has to be registration of rights, title, and interest in the patent. Okay, so form 16 and 13 seems like the right answer, but I think I did form number 6 and 13. Okay, so what form number 6 says is substitution of the name of the applicant. Let's say somebody else comes after me and I am assigning the rights to Uttam. So Uttam will apply to the patent office. He will file a form number 6 and he'll say that now the applicant name is changed to mine. So form number 6 has to come there. Form number 13 is amendment to the patent application. Okay, so amendment to the application means where you change the complete specifications itself. So here we are not doing that. We're only changing the assignment, right? So to my understanding, form 13 should not even come into play here. It has to be form number 16 and form number 6. So like I told you, form number 6 is substitution of the name of the applicant, right? Instead of my name, Uttam's name has to come. And form number 16 is registration of rights, titles, and interests of the patent in the patent office registry. Okay, is the answer B for 19? 19 is B. I'm a genius. Cool. So answer is B only. But what I did was I wrote option number A. Okay, because last year in 2022, the answer was form 13. For some reason, they said even this amendment has to come under form 13. I became a little over smart and I listened to the patent office. But unfortunately, the patent office became good this time. It was not evil. The answer is form 6 and form 16. Again, I kind of made a mess of it, just very clearly explaining it. Form 6 is for substitution of the name of an applicant. So whenever the applicant name changes, as in I've assigned the rights to some other party, form 6 has to be filed to change the name. Okay. Form number 16 is registration of all rights, titles, and interest in the patent office registry. Okay, in the official register which they maintain, things have to be changed there also, right? Now that I'm assigning something, the official change has to be made over there also, not just in the application. So that is form number 16. So when I'm assigning the rights to this industry, both the changes have to come into play. So form number 6 and form number 13. Cool. Form number 13 is for amendment to the application itself. As in when I'm changing some claim or I'm adding a new drawing or I'm changing the specifications, then it is form number 13. Otherwise, you don't go to form 13. Cool. Question 20. An application. Go on.
So during patent prosecution, we can file form 6, and after grant, we can file form 16.
You could say that. Yes. Yeah. Perfect. I think you've summarized it perfectly because one of his inventions has been granted. Form 16 is necessary. Post grant 16, pre grant 6. Spot on. I think you've summarized it perfectly. Beautiful. So question number 20. An application for a patent is open to public when till only after the publication, right? So just after the filing of the application, no, it has to be published. Just after publication of the application, answer is yes. Just after filing of the pre-grant opposition in the application, no, this is complete rubbish. It has to be published for you to even know about it, for you to file the pre-grant opposition. And lastly, just after the FER is issued, no. The answer is B. Question 20 is B. So are we right? 20B. Cool. So we have got 4 wrong answers. Let's keep track of that. 5 wrong answers, right? So we have lost 10 marks already. So Mohan went to London where he found a bicycle which works without a chain. Understand this properly, okay? Because this comes here, we talk about the exemptions to anticipation. Cool. So Mohan went to London where he found a bicycle which works without a chain. He realized that this bicycle is not available in India and wishes to import this bicycle to India and to file a patent for it in India. He approaches for your advice as per the Patents Act 1970. So right now, he has found a bicycle in London. That means it's available in the public. It has been worked in public in London. Cool. So what is the advice now? Mohan can be considered as a true and first inventor in India because his bicycle is not available in India. Again, this is complete rubbish, I think. Mohan can be considered as true and first inventor because he's the first person from India to know about the bicycle. Again, the answer is no, I think. Mohan can be considered as true and first inventor if he is the first importer of the invention to India. Again, I don't think the answer is right. Mohan cannot be considered as true and first inventor, has to be the correct option. Because whatever you say, I don't think of it from a common sense perspective also. Can you really call Mohan as the inventor of this bicycle? Of course not, right? So to my understanding, option has to be D. Mohan cannot be considered as true and first inventor. Whether can he apply for the patent in India? First, he needs to get the assignment right from the actual true and first inventor. That is my understanding. Okay. So 21 has to be D. let's answer lock kar diya jaye. So, ta-da-da-da-da. So what is the option? 21 is D. Chalo, 7 crore now. Okay, so where are we now? So, chalo, answer 21 is D only, right? Cool, cool, cool. So we are right. We have 17 crores, right? So 22, Style and Co, a US company, was granted a patent for a sewing machine in the US. Okay, pay attention. Okay, it's the same concept. So it's a US company. It has a patent for a sewing machine in the US. So I already told you guys, patent rights are territorial. So if you have it in the US, you can't get it in India. Okay, so it doesn't mean you get the protection in India. Joe is an entrepreneur engaged in the manufacture and distribution of sewing machines in India. So, okay, so Joe is the bastard here. So he's selling and distributing it in India, the patented invention in the US. So Joe came to know that Style and Co has not filed a patent application in India. In that case, Joe will get the patent in India. I don't think this is allowed. Only the same applicant get it if he files it under PCT or Paris Convention. And even then, it has to be done within 12 months. You guys know that, right? 12 or 31 months. Cool. Then Joe will get a patent in Europe. Again, I don't think so unless he gets the assignment right from Style and Co. Otherwise, he can't go for a patent in Europe. Joe can freely manufacture the invention and sell it in India. This is completely true because the patent rights that Style and Co. have in the US do not extend to India. So till they come to India and file the application and get it published, nobody can stop Joe. Joe cannot manufacture in India. This is not true because the patent rights don't protect the invention in India. So the answer has to be C. Let us lock the answer. Where is it? Cool. So 22 is C. Chalo, we are still right. Moving on, where are we? So then 23. Maithili invents a food processor that can chop vegetables and knead flour. Cool. Since the work was not complete, she filed provisional application on 21/2022. So when do you file provisional? When your research is not fully done, but you still want to book the priority date. So on 20th Jan 2022, she files it. She filed complete specification for her invention on 15th April 2022. So within 12 months, right? Because it happened within 3 months now here. So 12 months is her deadline. She is complied. Later, she invented a fruit juicer unit that can be connected to the food processor. So it's an improvement. So it can be filed as a patent of addition. She applied for a patent of addition under section 54 for the fruit juicer on 15/4/2023. So firstly, wait. So one second. So she invented the fruit juicer. Cool. They have not given a date on it. And more than a year later, she filed the fruit juicer's application also. Okay, on 15th April. Although the priority date is January 20th of the main invention. Cool. Assuming that both patents will be granted, the patent term will expire on what date? Very simple. I already told you guys, even if the patent of addition is granted, the duration does not get extended. It will be the duration of the main patent itself. So the main patent was granted on with respect to the filing on 21/2022. So this was the priority date. That means the 20 years is calculated from this. That means the duration of the patent is for 20 years from here. So the patent will expire on 21/2042. Okay. So even if she's filed the patent of addition 1 year later in April on 15 and all that, it still expires on 21/2042. So the patent term will expire on 21/2042 for both the patents. This is the correct answer. 15/4/2043 for both the patents is completely wrong. Of course, it can't be this for the first patent at least. Then 15/4/2042 for the first and 15/4/2043 for the second. This is also wrong because even though the complete was filed on 15/4/2022, the priority is drawn from the provisional date. Okay, unless she brings in some new claim or she had only partly disclosed the claim and she refined it later on. Until all that rubbish happens, this is still the priority date. So C is also wrong. Then 21/2042 for the first and 15/4. This is wrong because section 54 states what? That the duration of the patent of addition will be the same as the main patent. So the option is A. Right? So 23 is A, right? Yeah, 23 is A. Cool. One more correct answer. Where are we? So 24 now. Gopal has filed a patent application along with the necessary fees, but the application was not published. What could be the reason? What do you guys think? My understanding is Bastard has just filed it for time pass and he has not filled the complete specifications. Okay. So basically the application was not published. So for it to not be published, it means the complete specifications have not been filed because publication is automatic. Only for examination, you'll have to explicitly file form number 18. It has to be requested within 48 months. Publication happens by default within 18 months, unless you yourself want early publication under form 9. Other than that, there's no need for you to file any application. It will automatically be published. Only reason when it is not published is when you yourself have withdrawn the application before 15 months of filing, or you have not complied with the requirement. You have not filed the complete specifications within 12 months. So what has this bastard done? Gopal did not file a request for examination. Irrelevant, not needed. Gopal did not file a request for publication. This is also not needed. It's automatic. A pre-grant representation was filed against the application. No, this can be filed only after the publication. Lastly, Gopal only filed the provisional. This is the correct answer, because you'll have to file the complete within 12 months. If you don't do it, your application is deemed abandoned. It will not be published. 25, and then I'll take doubts. Gautam made a model of a speedboat which he invented. I already told you, right? Under section 10, model is not compulsory, but if the controller needs to understand, then he might request you for a model. So he files for a patent for the speedboat. Which of the following statements is correct? Model is part of the complete specification and is to be filed at the time of filing of complete specification. This is not true. Model may be requested by the controller, and then if it is requested, then you have to give it. Otherwise, it's not needed. Model is not a part of complete specification, but it has to be filed along with the complete specification. Again, it's not true. It doesn't have to be filed with it at all, and it's not a part of it. So B is also wrong. Model is not a part of the complete specification, but it has to be furnished if required by the controller. Option C is correct. Okay. And controller cannot ask for a model. Of course not. Controller is the god of the Patents Act. He can request for anything. Okay. So 25, the option is C. Cool. So one more correct answer. Then any doubts till here? It's very easy, right? Don't you guys think how easy these questions are once you know the basic concepts? Chalo, let's move on. Question number 26. Shiva was a great inventor for solar batteries and he filed 5 patent applications. Superstar. Then, though the patent were granted on all the 5 inventions, Shiva died before the date of grant of patents due to sudden cardiac arrest. Okay. Shiva's only son, Gana, approached you for advice. Which section of the Patents Act will you refer to? So this is the point where you need to know the sections. Okay. So if you know the blocks of the Patents Act, you'll be able to do intelligent elimination. Okay. So I can already tell you it's not section number 21. I don't know. Wait, let's not eliminate that first. Section number 44. Okay. So 44 talks about the term of the patent, if I'm aware. Okay. So to my understanding, substitution of the name of the applicant or the inventor has to either come under section number 21, powers of the controller, or it has to come under section number 53. Okay. So 50 or 53. 50 talks about something else, uses due to purposes of government or something, exemptions to infringement. 52 and 53. Okay. That's my understanding. So I think the answer has to be D. So here is where you make a guess. So 26 is B. Okay. Chalo, I was wrong. So what is 26?
Actually, it's amendment of a patent,
Okay.
Form 10. So
Okay.
that's it.
Okay. Cool. So I went wrong here. So I'll give you guys a technique to remember it. Of course, the technique is not great if I'm not able to remember it, but see, I've not revised it. Okay. I've not revised the act for almost 6-7 months now. So section number 44. Cool. So again, this is just rote learning. You'll have to remember it. Moving on. So section number 52 and 53 is a little unusual. So as far as I can remember, 52 talks about where if your patent has been obtained by fraud by a third party, then the controller has the power to change it to the original person's name. Okay, this is section 52. So I assume that 53 would be a logical continuation, and it's the power of the controller to change names in the registry. Cool. So that was my reasoning for 53. Cool. But if the option is 44, great. Then Raju Gomez, a US citizen, filed 2 applications with the US PTO on 28 April 2017. Cool. 2017 April, 2 applications. He filed a convention application in India on 27/4/2018. Immediately, convention applications mean Paris Convention. Okay. So 28/4/2017, 27/4/2018. So it's within 1 year. Okay. Then claiming priority from one of the US applications. Great. So he has claimed this priority. That means he gets the date. He gets 28/4/2017 only, even on this application in India. Cool. He filed a PCT international application on 25/4/2018. So I think this date is there just to confuse us. It's not really relevant because 25th April is much before that also. 2 days before that only, he has filed a PCT application claiming priority from the other application and entered PCT national phase in India on 31 March 2019. Cool. So this whole thing I think is irrelevant. So what he has done is 28th April 2017. In April 2017, he has filed a US application. Cool. And then in 2018 April, he has filed a PCT application. And then he has entered India on 31st March 2019. So is it within 31 months of this? Of course, yes, it's within 2 years. Okay, so it's within 24 months only. So definitely it's allowed. So this PCT application and then entering PCT national phase, this is allowed. Cool. So the date of the patent for convention application and the national phase application are respectively. So they're asking you the date of the patent for the convention application, as in this convention application in India. So what has happened here is basically he has filed multiple applications. So in Indian Patent Office right now there are two applications. Okay. So firstly, due to some confusion, he has filed a convention application also on 27/4/2018. This is also legal, and he has also filed a PCT beforehand in some other office, and he has come to India also through PCT on 31/3/2019. So on the controller's desk, the same invention has two applications, one through the PCT and one through the Paris Convention. So now what happens? One has to be scrapped, correct? But we're not talking about the scrapping. We're asking what is the priority date for both the inventions. So to my understanding, with respect to the Paris Convention, the priority date is still this only, 28/4/2017, because it has been filed properly under the Paris. And then with respect to the PCT also, since it is within 31 months, the convention priority date and the date of the patent is still the same. Okay. So the answer has to be 28/4/2017 for both. So the date of patent for the conventional application and the national phase PCT application are respectively 27/4/2018 and 25/4. I don't think all this is correct at all. So 27/4/2018 is somewhere here, not true because it draws on the previous priority. And then 25/4/2018 is also not true because even a PCT draws from the previous priority. Then 28/4/2017, yeah, this is correct. And 31/3/2019, this is not true because the PCT national phase also takes the initial priority date, the earliest filing date. B is also wrong, A is also wrong. 27/4/2018, this is wrong because the convention draws from the earlier priority. C is wrong. Then 28/4/2017. So 28/4/2017 is correct, and 28/4/2017 is also correct. So both have the same priority date. Okay. So it's a little bit of confusion, but don't worry about it. Both take the same. 27 is A. What the hell? What is 27? 27/4/2018. Where is it? 27/4/2018 and 25/4/2018. Wait, just give me a second. Okay. So 27, I can tell you for a fact the answer is wrong. Okay. The answer is wrong. 27 cannot be A. I'll just tell you why the answer is wrong. I cannot prove that this is right, but I can tell you for a fact A is wrong because what does the question itself say? He filed the convention application in India on 27/4/2018, claiming priority from one of the US applications. That means that he has already claimed the priority date of 28/4/2017, which means that this is not the priority date. It is this only. Okay. So immediately this option became wrong by default. So A cannot be the right answer. Okay. So the answer is D. This is a mistake in the answer key. It cannot be that. Okay. Is everyone clear on why this is the wrong answer? And did you guys understand my reasoning for why D is the correct answer?
Vishnu, is the question is regarding the priority date or the date of application? I could not understand.
So priority date and date of the patent are the same thing. Okay. So date of patent means the birthday of the patent. Birthday is the date of filing, the date of priority date. It's the same thing.
Okay.
Okay. So the answer is D for sure. I can tell you that. Okay. It's not A. I might not be able to prove to you that D is the correct answer, but I can prove to you for a fact that A is not the correct answer. Okay. Let's just see what I marked in the paper last year. So I think I have it written down here. 1 second. So SEM 4 patent agent exam. What did I mark in the paper? So question 27, right? Okay. So the correct answer was A, but I had marked D. I think I'm pretty sure on that. Okay. So these are again places where ambiguity creeps in, but I can tell you for sure that the answer is not A. Okay. 27A. I will check on it again, but for sure it is not A. The answer is D. Okay. Then 28. Your client who filed a PCT international application received the international search report from the ISA, and in the search report, category code X is mentioned against a prior art document. Category code X means that when the document is taken alone, the claimed invention is, this is what we worked on in TVS. Just Google it and understand it. So basically, when the ISR report comes, you'll get three kinds of objections. X will come, Y will come, and Z will come. Okay. So basically, when it is X, it means that it is novel but not inventive, not novel but inventive, either not novel or not inventive, not industrially applicable. Okay. So I think the answer is C. I'm not fully sure on this. 28, is it C? Yeah, 28 is C. Okay. So again, just Google this. I think that will be able to explain it much better to you than what I can tell you right now. Okay. So basically what the ISR report gives you is, if they give you an X category citation, It doesn't mean that its novelty is not there or inventive step is not there. It just means that one single document can defeat either your novelty or your inventive step. Okay, and why means that two documents when combined can either defeat your novelty or your inventive step. So whenever two documents are combined, it can't be novelty, it always has to be inventive step only. So X is generally for novelty or inventive step. So it can either be novel, not novel or not inventive. And Y, it is in general 99% of the time always for inventive step. Okay, so C is the correct answer. Apart from that, 29, Dr. Karan got a patent for a surgical equipment. Dr. Vimala used that patented surgical equipment for research purpose. Okay, so basically exemptions to infringement, I think section 47, 48 talk about this. Whenever the government uses it or you use it for research purposes, this is not infringement. Okay, Dr. Karan issued a legal notice to Dr. Vimala for infringement. Dr. Vimala approached you for advice. Which one of the following is correct? So Dr. Vimala can use it freely for research. Option A has to be the right answer. Dr. Vimala can use it for research but has to pay royalty. No, if you use it for research, it's exempted. No need of any royalty. Dr. Vimala can use it for research but has to take written permission. Not needed yet again. Dr. Vimala need not take permission from Dr. Karan but has to inform the patent office. No, not at all. 29 has to be A. Okay, 29 is A. Cool. So we've got 6 wrong answers, right? Let's remember that.
Vishnu, are there any other parameters for exemption when the patent is used by a private individual?
To my understanding, only research or academic purposes.
So academic and research basically, because I
yes.
have not been thorough with this. I thought it was for public purpose only that the patent can be used.
Just read the section once. It's very simple. Basically, if you do it for like social service and you're benefiting society, in general, it's allowed.
Okay.
Cool. So then section 30, question 30. Limera is a startup in the field of space engineering. They have applied for patents and wish to get them granted at the earliest so that they can carry out their business. Cool. So what is the advice now? Limera should file request for early publication and request for expedited examination. Of course, this has to be the right answer. Then Limera being a startup is not eligible for expedited examination. Read rule number 25C properly from the Indian patent rules. It tells you who all is eligible for expedited examination. Okay. So in general, examination takes a lot of time, 6 months, 8 months, 10 months. But what if you're like Limera and you want to enter the market fast? So you have to fill form number 18A for expedited examination. Okay, so that it's fast, because expedited examination, once you file the form, it has to be done in 2 months. Okay, but not everyone is eligible for it because the patent office will be inundated with requests for expedited examination. Everyone wants it to be done fast, right? So only certain people are allowed for it. Okay, so read rule number 25C. So the people who are allowed are basically female inventors. So if you are a female applicant, you're allowed. If you are a startup, you're allowed. If you have filed a PCT application with India as the Indian search authority, then you're allowed. This is to, again, promote the Indian patent office. And then if you're a governmental organization, suppose you're a PSU or some kind of governmental university or anything which is funded by the government, anything which comes under Article 12 of the Constitution, anything which can be state, then you're eligible for expedited examination. Okay, so startup is not eligible. This is not true. All startups are eligible for expedited examination. So B is wrong. Then Limera need not file request for early publication and request for early expedited examination as they are a startup. No, even if you're a startup, you're only eligible. You'll still have to file all this. Then Limera should file request for early publication along with the recommendation from ISRO. What the fuck is this? You don't need any ISRO recommendation. Answer is A. 30A. Yeah, cool. So we've got 6 wrong answers, right? So we have lost 12 marks. And we have got 36 marks. So we have scored 36 now, and we are still competing for 88 now. Let's go on now. So we have only like 20 questions left. I think we can finish the whole paper. What do you guys say? We'll go? Arya Avasti, are you there? Can we proceed?
Yeah, we can. For sure.
So we'll do the next 10 questions and we'll take a break before we come to question number 30. Okay. So the 30 marks, the set of questions. So right now, part B is kind of like the useless part of the paper. It's only 10 marks and 10 questions each. So very low effort to yield ratio. And there's a high chance of going wrong here also. So don't waste too much time here. Spend most of your time on part C. That's the gold mine. Okay. So we have got how much now? We've got 18 questions, right? So we have got 18 into 2, 36 marks right now. No. How many have we got right? We've got only 6 wrong, right? Yeah, we've got only 6 questions wrong. That means we've got 24 right. That means we've got 48 marks. We've already passed the exam pretty much. We need to get 50 to pass. Cool. So part B is of 10 marks and consists of 10 true or false questions. Okay. So A is statement 1 is true, 2 is false. That means 1, 0. Then B is statement 1 is false, 2 is true, so 0, 1. Statement 1 and 2 are both false, so 0, 0, and statement 1 and 2 both are true, so 1, 1. Okay, so 31 is time for putting an application in order for grant under section 21 shall be 6 months from the date of first statement of objection issued by the applicant. Issued to the applicant. So in general, once the FER has come out, you get 6 months of time. Okay, and this 6 months you can always file under form 29 and rule 100 and 138 or something. You can extend it. You can extend this by 3 more months. So you get 6 plus 3 months, totally 9 months. So 6 months is correct. Then time for putting an application in order for grant may be further extended for a period of 6 months on a request of extension made in form 4. So form 4 is correct. Okay, form 4 is for filing extensions, but you cannot extend it by 6 months. You can extend it only by 3 months. Okay, so the answer is statement 1 is true, statement 2 is false. Okay, 2 is false, 1 is true. So 1 is true, 2 is false is A. So it's 31A. Yeah, 31 is A. Okay, so you guys can see, right? This is a little more complex. There's a higher chance of going wrong, but they give simple questions. So company X is having a place of business at US and filed initial application at USPTO. Cool. After 6 months from the US application, company has done some modification and filed patent application for the same at Japan. Cool. So this is allowed because it's within 6 months and it comes under the Paris Convention. Then within 12 months from the date of US filing, company X filed an Indian application claiming priority of earlier 2 applications from US and Japan. This is also applicable because it comes within the Paris Convention. So both the Indian and the Japanese application have the older priority date. Cool. Then company X is allowed to claim priority of the US application only. Company X is allowed to claim both the priorities. Okay. So I can tell you for a fact that you can only claim priority of the earliest filed application, okay, which is the US application. Because why is this important? Because it'll lead to ambiguity now. Because if every country are claiming a different priority date, oh, in US I'm claiming the US priority, in Japan I'm claiming the US priority, then in India I'm claiming the Japanese priority, then I'll go to Pakistan and claim the Indian priority. So now the patent duration is different in every country. It'll lead to ambiguity. Okay, so you can claim the priority only from the earliest filing. So it's only the US application. So 2 is wrong, 1 is true. So if statement 1 is true and 2 is false, option is A. So it's 32A. 32 is B. What is B? 1 is false and 2 is true. Company X is allowed to claim priority of the US application only. Company X is allowed to claim both the priorities. Again, this is a degree of ambiguity, but I can tell you for a fact that the answer key is wrong. The answer cannot be B, but I'll just mark that it's B. Okay. So how do I mark it as B? Is there a B somewhere here? Chalo. So I'll put B here. So you guys know that B is the
Vishnu,
answer.
I think there were 2 answer keys issued for the 2023 question paper.
Is it so?
Can
Okay,
you just,
then I might have
can
the
you just
older one.
Make sure, because I think, yes, there is a 2 answer keys issued for that.
Okay. Maybe then this might be an older one and an incorrect one, but you
There
guys
is
have
there is a 2 answer keys.
Okay,
One is
okay.
answer key 2023 combined, and then there is answer key, final answer key.
Okay, then I have which one here? I think I have this one is
Tell me the
no, this
32
is
is
not
B.
the combined. This is not
32 is
combined.
B.
32 is B.
So the final set key, shall I share that
No.
final set?
I'll say leave it for now because
So that has B as the correct of 32.
okay, so B is the correct. But as far as I can tell you, it's not possible to claim both the priorities. And even if you're allowed to claim both the priorities, X is allowed. I'm not fully clear on this, but to my understanding, claiming both the priorities will lead to ambiguity. Okay, so I don't think this is the correct answer in the key. So let me tell you, at
A
least
is the final.
what happened?
In the final answer key, 32 is A.
Is it A? Okay, chalo. Then the answer is A. And you guys, did you understand the reasoning for A when I said A? Okay, cool. Can you guys just send the final answer key on the Google chat here?
Since we are doing set B, the 32's answer is B only. Check the set B. I think it's checking set A.
We're doing answer key. Okay.
Okay, cool. Let's just proceed. Okay, let's not waste time. But in general, always give this breathing space of around 10 questions to the patent office, because 10 questions, there'll be some kind of fuckery. So the answer is B. Okay, for this, let's assume that But to my understanding and to all common sense logic, it has to be A, because A, 1 is true and then 2 is false. Cool. Moving on. Question number 33. The term of every patent starts from the date of filing of the patent application. Okay, this is true. And then no suit or other proceeding shall be commenced or prosecuted in respect of an infringement committed before the date of publication of the application. Both are true. Only from the date of publication you have all the rights. So 1 and 2 are true. That means option is D. So 33 has to be D. So let's just proceed. Where is it? Array, I closed it. Just a second. Not this, not this, not this. Set B, 32, 33 is D. Okay, so we are right again. So we have made one question wrong in this, right? So we have lost one more mark. Then Sandeep has filed a patent application on 1/1/2019 for his invention, missile tracking device. Second, you read missile tracking device, it comes under secrecy, okay? And the application is considered to prejudice to defense. And he filed it on 1st Jan 2019. And on 25th December 2022, said secrecy direction is revoked, okay? So he filed it on this date, and then secrecy has been imposed. And then 3 years later, it has been revoked. The request for examination shall be made within 48 months from the date of filing, or the request of examination shall be made within 48 months from the date of revocation of secrecy direction. So again, this is a little ambiguous, but like I told you, all the timelines will be extended. Okay, whenever the secrecy is revoked, all the timelines should be extended by the duration of the secrecy. So that means it has to be from the date on which the secrecy is revoked. So 1 is false, 2 is true. That means if 1 is false and 2 is true, it has to be B. Okay, so is 34 B. A, 34 is A. Okay, complicated, guys. Chalo. And
I think it's on the discretion of.
It's on the discretion of the controller. Yeah, I think I've mentioned this in the meet also. If the controller so feels, he can extend
then he can extend it. Otherwise, it would have to be taken in consideration from the original application date.
But don't you think this is ambiguous? Let's say you mark this and then the patent office says, see, it is still possible, right? So definitely
Yes,
what you said is right.
Agree, 100% I agree.
So it is ambiguous. Okay, so cool. Apart from that, Gautami filed a patent application and wishes to get her patent application examined at the earliest. Okay, so you'll have to file for expedited examination. She's a female, so she's already eligible. She should file an expedited request for publication. She should file an express request for examination. Okay, so she has filed a patent application. She wants to get her application examined, but for examination you need to get the publication also, right? So she should file an expedited request for publication. She should file an express request for examination. Okay, so again, I don't know what the patent office's mind is. Of course she has to file the publication and examination, so by logic both have to be true. Answer has to be D. But then they will tell you that it's not called expedited request for publication, it is early publication. And this will be called as expedited examination. So if they're trying to fight me on the grammar, I can't help you. But by all logic, the answer has to be D because both are true. Statement 1 and 2 are true. Okay, so 35 has to be D. Let's see what fuckery they have come up with. 35 is C. Okay, so what they're saying is 35 is C, as in they're saying 1 and 2 are both false. Okay, I'll tell you why they're saying both are false. Because for publication, it is called as early publication. You cannot file an expedited request for publication. You can file for early publication. So they're just fighting on the name of it. Okay, and then you cannot file an express request for examination. It is called as an expedited examination, a request for expedited examination. So literally, they're fighting us based on the semantics of it. But otherwise, logically, you will have to file a request for early publication and a request for examination. Both have to be filed. Okay. Did you guys understand why the answer does not match what we believed it was? They are saying both are false. Cool. So they have said option
Vishnu, can the purpose be that in law you have to be very specific with regards to the words that you use? Maybe
if that is the case, yeah, cool. But then a lot of other issues also come, right? See, the patent office is, as per its convenience, it becomes exact. Some questions it's not so exact, and in some questions they're like, oh, you have to be exact. So there is a degree of ambiguity to it. Okay, so here is where luck comes into play. So in this paper I got 67 out of 100 when I was supposed to cross 80 plus. Okay, so this 67 I got is because I lost 33 marks. Why? Because of all this kind of rubbish that happened only. So give some breathing space for that. Then the claims lack inventive step due to prior art disclosure in a single document combined with common general knowledge. Okay, the claim lacks inventor step due to prior art disclosure in a single document combined with common general knowledge. Cool. The claim lacked inventor step due to combination of prior art disclosure in 2 or more citations. Both are true. Inventor step can be defeated even in a single document or in a combination of 2 or more citations. If it is a single document, you'll get X category citation in the ISR report. And if it is 2 or more citations, then you'll get Y category because it's a combination. But if it is novelty, it has to be in a single document. It cannot be from 2 or more combination. Okay, so option has to be both are true. 36 has to be D, and I'm pretty sure this the patent office has to agree on. 36 is D. Thank God. Cool. So where is D here? So I'll mark D here. Cool. Then 37. Where is it? In a case where an application processed by a startup is partly transferred to a multinational company. So we already saw where a multinational is transferring to a single person. Now a startup is transferring to a multinational company. The new applicant is not required to pay the difference in the scale of fees between the fees charged from a startup and the fees chargeable from an MNC. This is not true because all MNCs will use this clause to cheat the patent office. They'll file it with the startup and then they'll claim it. Now they're eligible for a expedited examination. They pay lesser fee, all the benefits. So no, the answer is no. They'll have to pay the difference. Then the new applicant shall file a request for the change in name of the applicant. Yeah, this has to be done under form number 6, right? So 2 is true, 1 is false. So that means 1 is false and 2 is true means option B, right? So 37 has to be B, right? 37 is B. Thank God. Chalo. 37 is B. Where is there a B somewhere here? Okay. So 37 is B. Then 38. While doing amendments in the specification, applicant, so amendment means form number 13. Then applicant shall provide a marked copy, clearly identifying the amendments carried out. This we did in TVS. This is true. And then applicant shall provide a statement clearly indicating the portion of the specification or drawing being amended along with the reason shall be filed. I think both have to be true. So 38 has to be D. What is the answer? 38 is D. Okay. So of course you have to give reasons. You can't just fall to make random changes. Cool. Then an application for patent is refused by the controller. Cool. The applicant wishes to challenge the refusal. Okay. So if your patent is refused by the controller, of course you can challenge the refusal. The applicant can approach the intellectual property appellate board. The applicant can approach the district court. So the IP has been abolished in 2019. It does not exist anymore. It's a very crafty question to ask. So the answer is B. So you can go to the district court. Again, if you fight me on technicalities, you can go for all grievances only to the high court. Okay. Technically, you cannot even go to the district court. But let's
Exactly.
see. So let's see how technical these people are. If they are very technical, both have to be false. But I think they will allow 2 at least. So the answer has to be 1 is false and 2 is true. So it has to be B, but I think they might go for C as well. Let's see, is it B or C? So we are at 39, right? 39 is C. Okay. So they are saying both are false. Spot on. They are being
I
very
think it's
technical. Okay?
high court only, na?
You can go into the high court. Okay. So
Yes.
we knew this. So assume this now that the patent office in the patent agent exam is very strict. So unless there is anything to the contrary, don't assume anything. So the patent act clearly states you can go only to the high court. You cannot go to any lower court than the high court. So yeah, you cannot go to the district court also. So both are false. So apart from that, legal representative means a person who in law represents the estate of the deceased person. This is true. We have seen, right, who has the rights to apply for patent under section 6, either the inventor, either the assignee, or the deceased person, like the representative of the deceased person. So legal representative means a person who files an application on behalf of the applicant. This is also very ambiguous and sketchy. In my understanding, I'll say it's only 1. Okay, it can't be 2. So 40 has to be 1 is true and 2 is false. So it has to be A. So what is the answer for 40? It is A. Okay, because only when the person dies, that person has a right to apply for the patent. No random person cannot go and apply on behalf of another person. Okay, so the answer is A. Cool.
Vishnu, what in cases when the applicant is supposed TVS and you are the inventor, and TVS applies for the patent on behalf, so cannot that be counted as a legal representation of
No,
your
no. What they mean
invention?
is, so in TVS, I am the inventor. Okay, I am the inventor who developed the invention, and TVS is the applicant on behalf of my invention because I've assigned the rights to TVS. If TVS goes to a lawyer to file it, let's say TVS comes to some patent agent and he goes to file it. So the patent agent can't put his name as the applicant because he is the legal representative of TVS. Doesn't mean that he is the applicant. So that's what they mean by this legal representative. This legal representative they mean as the heir, the legal heir of the person.
Sure.
Cool. So we only have 10 more questions. I think we can just wind up in another 15 minutes. So part C, okay. Let's go slow. It's a little complex here. So part C is 30 marks and 10 MCQs of 3 marks each. And this is a little complicated because at least 2 options are correct. Okay. So at least 2 means 2 have to be right. You can't mark just one or you can't leave all also. So Rajesh, a patent agent registered with the patent office, may be disqualified on the grounds. Again, this falls between section 118 and 130. So you're disqualified on the grounds that he is undischarged insolvent. That means you're bankrupt. He has been adjudged by a competent court to be of unsound mind. He, being a chartered accountant, has been guilty of negligence. He has been convicted by a competent court outside India of an offense to undergo a term of imprisonment. You guys will have to see the section. But even in the section, it's not completely clear. Like this chartered accountant and all is definitely not mentioned, and even insolvency is not mentioned. Let's make a guess. I think the option has to be B and the option has to be D. Okay. I don't think A and C are connected to this option. It has to be B or D. I might be wrong again. So 41 is A, B, C, D. Wow. Okay. So option is A, B, C, and D. And I think I got this right in the paper that came. Okay. So go through the section. I don't know the section clearly. I don't remember it. So probably it's still there. Okay. Because I remember getting this correct. Then 42, Mr. Ujjwal would like to know time limits generally available for extension of time using Form 4 in accordance with the patents law. So Form 4 is for extensions of time. So what are the extensions available? Again, you'll have to read the section itself. So this section itself requires you to know the act properly. Extension of 3 months is allowed for filing of declaration of inventorship. This, as far as I know, is true. Extension of 6 months is allowed for filing of renewal fees. This I'm not sure of. I don't think it's mentioned in the act. I think it's there in the rules. Extension of 3 months is allowed for filing reply to first examination report. So A and C are true. Okay, A is true, C is true. Then extension of 1 month is allowed for filing review petition. This is also true. You get 1 month time to review the controller's decision. So A, C, and D are true. B, as far as I'm aware, I don't think this is allowed because 6 months extension is not allowed. Okay, but you have 18 months of time to restore your lapsed patent. I don't think there is a 6 month time. I think it's a 1 month time. So I think B is wrong. A, C, D have to be right. Let's take a risk. Let's lock the answers also. Computer G. So A, C, D. So I really feel even in Kaun Banega Crorepati, the last 3 questions, they have to give more than one correct answer. Pretty screwed then. So 42 is B, C, and D. Unfortunate. Okay. So it's not A. Extension of 3 months is allowed, is not allowed, but extension of 6 months is allowed for this. Cool. So I'm wrong on this. Cool. Okay. So don't hold all this on my head, guys. Like all this is just rote learning. There's no logic to all this. Apart from that, 43, after filing the international search report and the written opinion of the ISA, the applicant may, what all can he do? He may enter national phase. This is completely true. I can tell you for a fact, this is true. Submit informal comments to the IB. Very ambiguous and sketchy. Then amend claims and file a demand for IPEA. This is true. He can file for international preliminary examination. And lastly, submit reply to ISR and written opinion to the ISA. See, both of these are true. Okay. So both are talking about the same thing, where you respond to the ISR. So can you submit informal comments or can you submit a reply to the ISR and the written opinion to the ISA? To my understanding, no. Your submission of reply itself is the amending of the claims. Why will you just reply to the ISR? Will you be fighting with the ISR? Because the ISR report is not binding. So will you go and tell your own chutia, what you're saying is wrong, it's rubbish? There's no point to it. So whenever you file a reply, it's to amend the claims only. Okay. So no idiot will send any reply to the ISR officially, or there's no need to submit informal comments. So to my understanding, for the common sense man with reasonable intelligence, the answer has to be A and C. So what is 43? A, B, and C. Okay. So this is where you start losing marks. Submitting informal comments, there is no logic to it. And I don't think any place talks about this. Even on the WIPO website, I don't think this is there. Where the provision
Vishnu, this is IB's what intelligence bureau?
No. IB is the Intellectual Bureau, which is the official head of the WIPO office in Switzerland.
Okay.
I mentioned this in the previous meet. Okay. So all this, nobody knows. Okay. Some controller would have read it in some grandfather's website and he's put it here. Cool. Whatever. So go moving on. Don't get disheartened. The other questions are easy as far as I remember. So parent office has objected novelty based on a cited document and issued first statement of objection to you. Okay. So novelty has been objected and FER has been issued. You can do the following acts. So this question should be easy. Then you can do the following acts. So what can you do? If you can show to the satisfaction of the controller that the priority date of the claim of your specification is not later than the date on which the cited document was published. This is allowed. Okay. If you have filed it on the same date, that means you have not been anticipated. Okay. I think this is section 33. Okay. So this is allowed. A is for sure true. Once again, A is true. Then you can amend claims of the complete specification to overcome the citation. This is also true. Amendment is allowed under form number 13. Then you can withdraw your application. This is also true. You'll get a small refund. If you have not done the FER, you get up to 90% of refund under form 29. Then you can challenge the objection of novelty in court. This is a little sketchy, but as far as I am aware, no, till the grant you cannot go to court. Okay, only upon the grant the court proceedings start. So objection of novelty, you cannot go directly to court immediately. But let's say the objection has been made, okay, to novelty, and your parent of application has been deemed abandoned or withdrawn or not allowed. They've not allowed your patent. Then you can go to court. Okay. So again, this is ambiguous. At what point are they talking about the challenge? Because if they don't allow it, of course you can go to court and challenge it. But at what point are they talking about? So when he's issued the first statement of objection, so now you can't challenge the objection in the court. You'll still have to respond to it within 6 months. So I think D is wrong. Answer has to be A, B, and C. So the thing in this section is you will get the correct answers. The question is, will you get all the correct answers? Okay. So 44 has to be A, B, C. What does he put? A, B, C. Oh, chalo, 5 really. We've got 1 3 mark. Thank God. Chalo, 45. Term of the patent application starts from. Okay. So I want the answer from Subramaniam here. Date of filing of provisional specification. Date of filing of complete specification if the provisional specification is followed by the complete specification. Date of entry in India in case of PCT national phase application. Date of filing in India in case of convention application. Yeah, tell me the answer, Subramaniam.
A and D.
Date of filing in India in case of convention application. Even then, don't you
A.
think it will draw from the earliest filing date?
No, it has to be one country which.
He has seen the answer key.
I'm not seeing the answer key. I know it's A and D.
Okay, fine. Then answer lock kar diya jaye. So 45 is A and D. Okay, cool. So
He has seen it.
okay.
Yeah, fine. Uttam, yes, is right.
No.
In this case, the earlier answer, that date should be the correct one only, right? That 25th April US date and
No. That is still wrong. I'll tell you
Vishnu,
why.
can you explain between C and D? Because I'm confusing.
I'll tell
between
it to you.
C
Wait.
and-
I'll tell you even with respect to the old answer why that was still wrong. Okay. So what they mean is when you file an application in India, no, they are talking about you claiming it as a conventional application. Okay. As in like, let's say you file the application in India on 1st Jan. Okay. And then 6 weeks you wait for it. And then you have to file it in Canada. Okay. The second you file it in Canada, you'll have to submit an undertaking to the parent office, correct? You'll have to file under section 39. You'll have to file form 3. You'll have to inform them that you're filing it in Canada, Pakistan, USA. In which case, your application has been deemed as a conventional application now. Okay. So your initial application that you filed on 1st Jan, it is still the date of filing, will be the priority date now. Are you understanding what I'm saying? So you have not filed a separate convention application. Suppose you file the first application in the USA on 1st Jan and on November 1st, you file it in India. It doesn't mean that your priority date has changed. Okay. You cannot claim from 1st of November, your patent application's term does not start. It will claim the earliest priority. This is the point of the Paris Convention. Okay. It will be from 1st Jan only, not the date of filing in India. Okay. So what they mean in this option is when you file the first application in India and you claim that only as the conventional application, then the term of the patent starts from the date of filing in India. Okay. And what option C is saying is the date of entry in India in case of PCT national phase application. See here, they're not saying date of entry in India in case of a conventional application. They're saying date of filing in India. So date of entry means you filed the PCT somewhere else or you're drawing in other priority, and now you're entering India. So whenever you're entering a country, that means you're claiming a priority of an earlier application, the earliest filing. Okay, so it can't be the entry date. So C is wrong. Okay, so with respect to D also, I told you you're claiming the earliest entry, and in this case they're not talking about any entry. They're claiming the Indian application itself as the conventional application. So the date of filing of the conventional application is the priority date. Okay, and what Subramanian said is spot on. Date of provisional, by all common sense understanding, this has to be correct. So why is it different from question number 25 is that here they are talking about a conventional application which has been filed in India, US first. So US PTO had it first, and then it is entering India. Then you are filing it in India, claiming priority from the other US application. Then it is claiming the older priority date, okay, not the date of filing in India. So just by virtue of this sentence, since it is claiming the earlier priority, this answer is wrong. Okay, it's completely wrong. So you cannot have different priority date, because if a different priority date comes into play, let's say the US application is filed on 1st Jan and you have filed this in November and you're claiming and you have a different priority date for the Indian application, that means the application itself is anticipated. Okay, it will be anticipated. The patent office will say that this application has already been filed in the US. Since you don't have the same priority date, your priority date is after this priority date, so your invention is anticipated. It is not novel. It has no inventive step. So for it to be exempted from novelty and inventive step citation and objection, it has to claim the earliest priority. Okay, so that question is 100% wrong. I'll tell you that. Okay. Apart from that,
the term begins from the earliest priority date, right? In India,
earliest priority date. So in this option D also, I think they're assuming that the earliest priority date is the filing of the conventional application itself. You're not entering India based on the Paris Convention. You've already come to India. India is the first place you filed the conventional application. That's what they mean. Okay. Again, these are all questionable answers. Okay. Apart from that, 46. Who are eligible for the expedited examination of applications? Read rule number 25C clearly gives you natural persons as applicants, wherein at least one of them is female. So yeah, this is true. The answer is at least. Okay. So literally just call another female applicant with you. You're entitled for expedited examination. Natural persons as applicants, wherein at least one of them is an Indian citizen. This is not true. It's not available to Indian citizens. You'll have to meet other criteria. Startup, but not a small entity. I don't think this is also true, because it is startup and other medium small entities, and then startup or a small entity. This is true. Okay, so 46 has to be A and D. Chalo, thank God.
Vishnu,
Wow.
what is exactly the difference between startup and a small entity? Are there any parameters?
Exactly. There is an exact difference which is given in this Brahmastra only. Where is it? So they've given the exact difference between a startup and a small entity. See here, it's given here. So the age of the company, it shouldn't be more than 10 years. It should be a private limited company. It should not have a turnover of more than 100 crores. And it should not be some kind of split up. As in, like, TVS can't split itself into 5 companies and say that, oh, we are not exceeding 100 crores. We are a startup now. And then lastly, it should be towards the creation of development of a product or improving India, stuff like that. And there are more criteria.
Small entity, I guess.
So go through the MSME criteria. Okay, so the DOPT, the Department of Personal Training or something, has released the criteria. You can't have machinery, an investment in machinery of more than 50 crores for a small industry, and for medium it's more than 250 crores or something like that. You'll have to know this. It'll come in the exam. Okay, so read the criteria for startup, for a small, and for a medium scale industry. Apart from that, coming back, that way the exam is fantastic. They cover the entire syllabus. They don't leave any portion unchecked. Okay, so 47, last 3 questions were done. Which is true about statement and undertaking regarding foreign applications? Immediately your mind has to go to section number 8, section number 39, and form number 3. Okay, statement and undertaking under section 8.1 shall be filed within 6 months. Timelines I don't remember. Shall be filed within 6 months from the date of the filing of the application. I'm not sure if it is 6 or 3 months.
It's
Whatever.
6 months in case of statement and undertaking. Wherever there is a timeline, it is only 6 months only.
Okay,
In
then
case
6
of
months.
statement and
Then
undertaking.
applicant shall inform the controller regarding details of the same application or similar applications filed outside India within 3 months from the date of filing of such application under section 8.1. I'm not sure, again, might be true. Then applicant shall furnish information relating to objections in respect of novelty and patentability of the invention within 6 months from the date of requirement of the controller. This has to be true because you have to furnish. And then applicant shall furnish information relating to objections in respect of novelty and patentability invention immediately as and when required by the controller. Okay. Again, like this is again ambiguous, not fully clear. It can be A and C or it can be A and D, not fully sure. Let's go with A and C. So 47 is A and C. Okay. So you have a time limit of 6 months. I think Uttam is spot on here. So just remember that 6 months, whenever it is a foreign undertaking or any information regarding the foreign thing, there's a deadline of 6 months. Not as and when the controller requires, it's always 6 months, A and C. Moving on, Rohan happened to visit Himalaya along with the trekking team. While staying there, he wrote a book related to Himalayan mountain ranges. So automatically book writing means copyright. Took some video, again copyright. Made a novel, an attractive device for easy trekking. So this is patent. And then discovered a stone naturally occurring there. Okay. So he wishes to get IP rights on all of them and approached you for filing the application. So what all can he apply register for? Copyright for the book and video, for sure. I already mentioned this. So this is true. Then he designed for the stone and copyright for the book. You cannot get a design for any naturally occurring substance like a stone. So this is false. Then patent for the device, but not design for the device. Again, there is no reason for you to not get the design because it is attractive, right? There is some aesthetic feature to it. So C is also wrong. Patent and design for the device is correct. So option has to be A and D. 48 is A and D. So see, they are a little merciful. They do give you easy questions like this. Then 49. A patent application was filed by a company A on 1st Jan 2021 and was published in the Patent Office Journal on 1st July 2022. Is it within 18 months? Yeah. So it's 18 months till this, so it has been automatically published. The first statement of objections was issued by the Patent Office on 3rd August 2022. Cool. Applicant filed a response complying with all the objections on 5th October 2022. So it's within 6 months plus 3 months. So this is also valid. Then 10th October 2022, the applicant noticed that a competitor, company B, is selling a product which utilizes the applicant's invention that was disclosed in the patent application. Choose the correct option. So any infringer, the infringement is from the date of publication. So it was published on 1st July 2022. So from this date, if the infringement happens, you can sue them only after the grant of the patent. Okay. So the company A may send a legal notice to company B. This is spot on. First thing is true. Company A may file an infringement suit in the court. Not yet, only upon the grant. Upon the grant of the patent, the company A is entitled to seek damages from 1st Jan 2021. No, not from the date of filing. Upon the grant of the patent, the company is entitled to seek damages from the 1st July 2022 from the date of publication. A and D are true. I think we are spot on. 49 is A and D. Okay, so we are right. Moving on to the last question. See, even though we got like 4 questions wrong in a row, we've got 4 right also in a row, right? So technically look at the positives. So 50 is a company X files a patent application which upon examination was objected on the ground that the application contains a plurality of distinct inventions. So this is divisional application. I think it comes between section 12 and section 18, where the controller, if he feels that you're talking about 2 different inventions, he can order you to divide the application into 2 separate applications. So X files a further application in response to the objection raised in the examination report. Choose the correct options. Cool. Let's see what all happens now. Okay. So the complete specification of the further application should include only the matter which was not in substance disclosed in the complete specification of the first mentioned application, as otherwise it would amount to double patenting. Okay. So let's just clear up some ambiguities in the question. So what they're saying is X has filed a patent application. Okay. Now the patent office is saying there are 2 or more inventions in this. You'll have to divide the application. So now X is like cool, and now he files another application now. That's what they mean. Okay. X files a further application, a second application in response to the objection raised. So now there are 2 patent applications. Okay. Let's say I have a smartphone with a camera and a thermal sensor. Now controller is saying there are 2 separate inventions. So I file a patent application with a camera. Cool. Now I'm filing a further application with this thermal sensor. Cool. So choose the correct options. The complete specification of the further applications, the one with this thermal sensor, should include only that matter which was not in substance disclosed in the complete specification of the first mentioned application, as otherwise it would amount to double patenting. This is spot on. Okay. This is completely true, because now if both the complete specifications of the patents both speak about the same thing, then how will you be able to license the invention later on, right? It's not possible. The novelty is defeated, inventive step is defeated, it will create ambiguities later on. So the further application should not include any matter which was in substance disclosed in the previous application. Then the controller may require such amendment of the complete specification filed in pursuance of either the original or the further application as may be necessary. So yeah, he may require other amendments to ensure that neither of the set complete specifications includes a claim for any matter claimed in the other. This is also spot on. Claims cannot match. Okay, your claim has to be separate. Let's say I have a property, and in the property register, my property is 30 by 40 on the east and the south and the east and the west, and it is I've claimed it on the road next to this mall, next to this building, next to this school on the north, east, west, south. Let's say Uttam also buys a property, and in his property, he's claiming portions of my property. He's telling 40, 50 site, and he's claiming a small portion. It can't be registered, right? Two people cannot own the same piece of property. That's what they mean. So every claim has to be original and individual. So the controller may require you to amend such that the claims are not matching, so that the claims of one are not claimed in the other. This is also true. Okay. Option B is also true. C, the complete specification of the further application should not include any matter not in substance disclosed in the complete specification filed in pursuance of the first mentioned application. The complete specification of the further application should not include any matter not in substance. Again, don't you think C is talking the same as A? I can't tell the difference between A and C. Maybe just the word double patenting is not there, but C is there. And then D is both A and B. If you guys have, like, you can see how ambiguous and bullshitty the options themselves are. But I think the answer has to be A, B, and C. Let's see what the answer is. For if my prediction of how the patent office is correct, it will be A, B, C, D. Let's see what the fuck they have done. 50 is B and C. Okay. So what they mean is all this is true. It's just that it's not called double patenting, because otherwise A and C are the same thing. Okay. Till here, till the first mentioned application is true. It's the same thing. Just that it would amount to double patenting is not there. But again, this is not true. It is called as double patenting only. Okay. Just because the name is not mentioned, they're saying that it's not true. B and C are correct. Okay. Maybe you can use some kind of intelligent elimination, because D says both A and B are there. And for some reason, you know that D is not the answer, right? So I don't know, some way you can eliminate A using that, and then you can get D and B and C. I don't know. It's complex. It's ambiguous at best. Cool. So I think that brings us to the end of this paper, right? Any questions? I think we're done, right? Cool. Apart from that, I think paper 2 will solve it next week with a bit of the drafting. Paper 2 does not have anything complex. Okay. So most of the fuckery is over here, and your goal is to cross 50 marks out of 100. And I can tell you for a fact, we have crossed 60. Okay. We have got some wrong answers, but in general, I think we have crossed 55 at least. So we are passed in today's exam. So apart from that, yeah, I'll save these and I'll send them to you. Just a second. Cool. So it's saved. Yeah, apart from that, anything else? I'm ending the recording here.